Mr. David Davis.
Thank you, Mr. Streeter. I propose to speak to new clause 3, which is on the order paper in my name. It's entitled Intercept Evidence Use in Legal Proceedings. This is a probing amendment. I do not propose to press it to the vote on this occasion. If I had done, I would have incorporated in the amendment, or sorry, the new clause, the relevant legal machinery required, which is complex but not actually really difficult. My aim is to try and provoke some sort of non-partisan debate on what is a cornerstone of counter-terrorism strategy, the legal treatment of intercept evidence. And if need be, I'll come back to this on report stage, depending on what the Minister has to say and the Government has to do in the meantime. The United Kingdom is effectively unique amongst major Western powers, with common law powers and the European Union countries, in not allowing the use of intercept evidence in court under current law, or with a few exceptions I'll come to in a moment. Why this is? Well, it's difficult to know. GCHQ has always resisted, and its predecessors always resisted putting any intercept in the public domain, frankly, since the invention of the telephone. I suspect in the early days it's because gentlemen thought it was ungentlemanly to listen in on other people's conversations. But today, the protection of technique and the protection of capacity is the argument which is marshalled by the agencies. It's an attitude which is extremely different from every single other agency of its sort in the world. Every one of our allies in the Five Eyes and beyond are, of course, equally concerned about protecting capability, but they also put as a high priority the prosecution and conviction of terrorist and serious crime, and they manage to square that circle in a way which we do not appear to be able to do at the moment. Now, the effect of this is it makes it more difficult to achieve convictions in court in terrorism and serious crime cases, an area where Lord Lloyd of Berwick talked of the difficulty of obtaining evidence on which to charge and convict terrorists, particularly those who plan and direct terrorist activities without taking part in their execution. Incredibly important in dealing with the Al-Qaeda style of terrorist operation, where the bit players disappear in a cloud of vapour as they carry out their evil tasks. Now, I pay attention to Lord Lloyd because he's an appeal judge, he's a past intercept commissioner, he's the man the last Conservative government put in charge of reviewing all terrorist legislation, and he is a strong advocate of using intercept in court, as indeed is the past Director of Public Prosecutions, Ken MacDonald, and the past Attorney General, Lord Goldsmith, and indeed are a very large number of senior police officers who are in charge of counter-terrorism. Now, the result of not being able to use intercept evidence in court is greater difficulty in getting convictions. That, in turn, has been used as a justification in the past for example, the indefinite detention under Part 4 of the Anti-Terrorism Crime and Security Act in 2001. It's been used to justify control orders and TPIMs. It was used to justify 90 days, then 42 days, then 28 days detention without charge, all of which I'm glad to say were either defeated or have now been revoked. But perhaps worst of all, the difficulty of obtaining convictions encourages too much reliance in our counter-terrorism agencies, that's the intelligence agencies and the police agencies, too much reliance on disruption rather than prosecution. And that's an approach, since Lady Herman's with us, that's an approach which patently failed in Northern Ireland. The disruption rather than prosecution approach, and it leaves too many terrorists on the streets, and that leaves the agencies with a bigger job and a very difficult, maybe impossible task of assessment, as we see by the outcome and the ISC's report on the Lee Rigby murder, where the agencies fell down on assessment of the murderers who were known to them, and indeed in the 7/7 bombings, where again the bombers were known to the agencies, but they were judged too far down the list of 2,000 suspects. This is a problem which is made worse by not prosecuting and putting in prison after conviction terrorists, and the lack of use of intercept makes that worse. Now, GCHQ has obviously told Chilcot and the subsequent Privy Council panel on this that the use of intercept would not deliver many extra convictions. Frankly, that is very hard indeed to square with the evidence from other countries. When I was looking at this in about 7 or 8 years ago, I went to America to speak to all the various three-letter alphabet agencies over there, plus, most importantly in this context, the Department of Justice, to talk to them about their use of intercept. And the things that were said, let me just quote one from the man who was the second highest in the Department of Justice, the highest non-political appointee. He said, I quote, "Not a single counter-terrorist or organised crime case has been successfully prosecuted in the United States without the use of intercept evidence." And that was a major part of their massively successful counter-terrorism and counter-mafia operations. Now, I picked mafia, counter-organised crime operations, because they're quite similar in the nature of the problem. Getting witnesses is difficult. Getting intelligence is difficult. They kill their witnesses. They're very sneaky. They're very clever about their use of communications. In the case of the organised crime syndicates in America, they're better advised than the likes of Al-Qaeda by lawyers and indeed technical people. What do the Americans do? The Americans have what's called a CIPA process. That's the Confidential Information Protection Act, I think, process, which involves a CIPA court. A CIPA court is a bit like SIAC. It's a court in which you have security-cleared prosecution and defence counsel, you have a security-cleared judge, and it's all held in secret. And that court decides on what evidence can be put to the main trial. Now, this is a big battle that goes on. It prevents malevolent fishing expeditions by malevolent lawyers or badly judged lawyers. But what it does is it ensures that both sides of the case get proper treatment, proper justice is delivered. What he said was, if we win the CIPA case, the main case goes straight to plea bargaining. In other words, the other side give in, they accept the outcome. He viewed, his words, the British approach as incomprehensible. That was his phrase. But it's not just them. All the other English-speaking peoples in the Five Eyes do much the same. Australia's intercept arrangements delivered in the year I looked at, 2006, just short of 1,500 convictions in a combination of serious crime and counter-terrorism work on the basis of intercept. Their Director of Public Prosecutions was even fiercer. His words at that time were, if you don't use intercept against terrorists, you are not being serious. That was what he said. Now, there are various problems in the UK, which I'll come back to in a second, under the ECHR regime, which makes it a little bit more risky for us than perhaps others, but nevertheless, there are issues that I think can be dealt with. Now, the agencies talk about protecting methods or techniques and operations. They're both perfectly legitimate concerns, and I think we need to deal with them. But let's deal with techniques first, or methods first. Now, GCHQ is good, but it's no better than the NSA, and it's a tiny size by comparison to the NSA. The techniques that are used to intercept are commonly in the public domain in court in all of the Five Eyes countries, in America, in Canada, in Australia, in New Zealand. In the days of the internet, you can get court records from around the world. And if we're worried about Al-Qaeda knowing what we're doing, they can know by looking at every other country in our alliance, because they do the same things. So I don't think that argument, the argument of technique, stands up much at all. But you can even protect it given that. Secondly, the question is of protecting operations, and I'll come back to an example of that in a moment. Individual operations and individual agents. I think this is manageable too. All the countries, USA, Australia, Canada, New Zealand, Israel, have techniques of certification and warrantry that explicitly protect operations and operational security. Again, from malevolent defence lawyers going on fishing expeditions. And I'll cite the example in a minute. Now, there are, we should say, be clear before I go any further, that there are a range of exceptions to the ban on intercept evidence in court. One is intercepts carried out in other countries. We have this extraordinary arrangement in our law that we can use intercepts arrived at abroad but not in the UK. So quite how we deal with the issues of technique and protection of operations there is interesting and debatable. After the Heathrow bomb plot, a number of the suspects who were charged were not convicted, and some of those lack of convictions were critical. 3 in particular were so critical that they were retried: Ali, Sawa and Hussein. And the evidence that convicted them was email intercept evidence obtained from Yahoo in California. It led to their conviction in 2008. Now, incidentally, that demonstrates straight away the value of intercept in difficult cases. But that intercept data was not initially released because the US felt initially that it compromised an existing operation, one against a man called Rashid Rauf in Pakistan. Rashid Rauf disappeared or died, we don't know, under strange, mysterious circumstances, and of course the information then was available because that operation was no longer sensitive. So a simple example, both of the effectiveness of the mechanism and also the fact that you can control the information under using American or other Five Eyes processes. You can control the information to release it when appropriate and do it safely. The other 2 exceptions which the House should be aware of to the use of intercept evidence in court is intercept of telephones and other communications out of prisons. That's open. So, for example, the Soham killer, Ian Huntley, was convicted very largely on intercept evidence arrived out from there. And bugging. If we bug a phone, we can use the information. But if we intercept the phone, we can't. This is an extraordinary distinction, particularly given that if you put a physical bug in that, we could use the data. If you put a software bug in it, you can't. I mean, it's an astonishing piece of out-of-date law in that respect. And it seems to me it needs to be brought up to date. So, as I said, the use of the intercept ban is inevitably to push agencies towards disruption rather than prosecution. And this, of course, is inevitably less effective and leads to a progressively more difficult problem for agencies over time. Now, the Privy Council Committee very nearly recommended allowing a tentative use of intercept evidence some time ago after Chilcot. But they appear to be put off at the time by one single case that came up at the last minute. It's the case of Natunen versus the Finnish government. And the ECHR stepped into that case, which devolved around intercept, and struck down the conviction. What had happened was Natunen was convicted as a drug smuggler, and in the case some intercept evidence was used, and it turned out that the police had destroyed some other intercept evidence which could have been, may have been, exculpatory. And this was the case that sort of shocked the Privy Council Committee. The reasoning for the change of stance at the last minute, as I understand it, was that Chilcot laid out 5 principles, a couple of which essentially said the agencies have at all times to control the recording, the transcription, the storage, and by implication, the possible destruction of any evidence. And this should only be under the agency's control, not under judicial control. Well, of course, this leads you to a problem. If they destroy evidence without judicial control, you may actually change the balance in a court case. So you can't do that. So it seems to me we need to revisit that and start to try to copy some of the techniques used by other countries. Now, this is very technical at one level, but actually very straightforward at another. Because remember what I said about the way the Americans do this. The Americans have a court which goes through this information and sifts out what is available to put in front of the court, which is fair to both sides, which doesn't allow the compromising of proper intelligence operations. That court is very like SIAC, very like a court we already use. And incidentally, SIAC can hear intercept evidence. And although SIAC has had its rulings overturned from time to time by the ECHR, it has never had any sort of instruction to put that intercept evidence in the public domain or make it available to people who are perhaps not responsible. So this issue is resolvable. It's capable of resolution. I think we have been over-nervous and we have been over-attentive to the understandable worries of GCHQ in the past. and of the other agencies. And that's why those who work with this, the policemen and some of the agencies who work with them, are more. Of course, I'll give way.
Thank you, Mr. Streeter. I've listened intently to the contribution made by the right honourable gentleman. Could I just ask him just to reflect upon the fact that when we had diplock courts in Northern Ireland, they were supported by one section of the community and they were absolutely hated and despised by another section of the community. We don't have diplock courts any longer in Northern Ireland. But if his proposal were in fact to be legislated upon, and we have the secret court that sits and hears all of the evidence and the intercept evidence, which I agree should be allowed into court, how does he think that would be received in Northern Ireland?
Well, I speak as probably one of the last people to give evidence in a diplock court against a terrorist who was convicted and under the Good Friday Agreement promptly released. Very frustrating process too. Yes, of course, there is a problem of acceptability of any secret court. She will know. I fight vigorously against the idea of secret justice. But this is not secret justice. This is a decision to let into the public domain more than is currently let into the public domain. Sometimes information is exculpatory. Sometimes it is. And indeed, one of the problems that has come up with SIAC is the agencies have not been very good at their evidence discipline, and in at least one case, a case was struck down because a special advocate called who's now a judge, discovered that the same passport was being, the MI5 was claiming that one person that they were bringing a case against 1 week had used this passport to cross the border, and then the next week they brought a case against somebody else claiming he used the same passport on the same day in a different place. So they do have their weaknesses, but nevertheless it's significantly better than where we are now at the moment, where we may use intercept evidence, for example, in TPIMs and control orders. I happen to think TPIMs and control orders are a complete ludicrous policy, because it leaves people who perhaps ought to be inside prison out on the streets. And they should be called uncontrolled orders or non-control orders, really, because all the dangerous ones disappear. So, of course, it's not easy. But, and of course, there is an issue of presentation. But I think if you have fair representation from both sides to decide on what information can be put in the public domain, it's as close as you can get to public justice. And that's the point, as close as you can get to open justice. But most important of all in this, it actually starts to make the agency's job more possible. I mean, we have had a situation now, and even some of the ISC have effectively criticised. A member for Knowsley, I think, a week or two ago, criticised the fact that the agencies seemed unable to deal with the thousands of suspects they have in front of them and sift them in such a way as to find the ones who are really dangerous. That's what happened at 7/7, it's what happened at 21/7, and it's what happened in the murder of that terrible murder of the soldier, Lee Rigby. So this will actually give us a powerful anti-terrorism weapon and make the job easier to do, reduce the size of the target, both very important. It also, at the end of the day, will deliver justice, because I take the view that one of the most important things that we can do with would-be terrorists and terrorists, actual terrorists, is to convict them in a court of law so their own communities understand what they've been doing or what they've been planning, and then punish them properly and take them out of circulation so they're no longer a threat to the public. And it seems to me that we need to take this incredibly seriously. Frankly, this issue is more important than most of the other issues in this bill. I probably accept prevent, but the rest is more important than most of the rest. And it seems to me that the government really ought to take a grip of this issue after 30 years of indecision.